This morning are Commissioners Duffley, Hughes, McKissick, Kimmerite, Brawley, and Tucker. In compliance with State Government Ethics Act, I remind members of the Commission of our duty to avoid conflicts of interest and inquire at this time as to whether any member of the Commission has a known conflict with respect to matters coming before us this morning. The record will reflect no conflicts have been identified, so we will proceed with Public Staff Item 1.
Good morning, Commission. I'm Evan Lawrence, an engineer with the Public Staff's Energy Division. Electric Item 1 consists of an application for a CPCN for a poultry waste to energy electric generating facility. The Public Staff recommends the Commission issue the requested certificate. Thank you.
Move approval of staff recommendation.
Second.
All right, it's been moved and seconded that the item be approved as recommended by the Public Staff. Questions or discussion on that motion? All right, all in favor indicate with an eye. Is there anyone opposed? That motion carries. Thank you, Mr. Lawrence. All right, Public Staff Item 2.
Good morning, Commission. My name is Jordan Nader, an engineer with the Public Staff Energy Division. Item 2 is a request by Piedmont Natural Gas Company for approval to adjust rates under Appendix H of its tariff and service regulations effective January 1st, 2024. On December 6, 2023, following the publication of the agenda for this staff conference, Piedmont filed reply comments to the Public Staff's comments stating that it agrees with the Public Staff recommendations. The Public Staff has provided Commission staff with a revised proposed order, including that information. Public Staff has reviewed the application and information provided by Piedmont and recommends the Commission approve the application as filed.
Move staff recommendation.
Second.
All right, it's been moved and seconded that the item be approved as recommended by the Public Staff. Any questions or discussion on that motion? Hearing none, all in favor indicate with an eye. Is there anyone opposed? All right, that motion carries. Thank you, Mr. Nader. All right, Public Staff Item 3.
Charles Junis, Public Staff, Water, Sewer, and Telephone Division. Item 3, docket number W218, sub 551. Aqua North Carolina, Inc. filed an application for authority to transfer its water system serving the Northgate subdivision to the town of Fuquay-Varina, which is exempt from Commission regulation. The Public Staff has reviewed the application and recommends that the Commission issue the proposed order approving the settlement agreement, approving transfer to owner exempt from regulation non-pro-tunc, canceling franchise and requiring customer notice.
All right, thank you, Mr. Junis. Question for you. Has the asset transfer to the Lear Corporation already taken place?
It is my understanding that the actual transfer has not been closed. However, service is being provided by the town of Fuquay-Varina.
Understood. Okay, so customers are receiving service from the town. Assets are still titled with Aqua, but subject to consummation of the transaction will transfer to the Lear Corporation.
Correct. That is my understanding. And then the necessary assets to operate would pass to the town. So the water mains will be owned and controlled by the town.
Okay. All right. Thank you for that clarification. All right. You may, Commissioner McKissick.
Hey, Mr. Junis, I'm just curious. I mean, I know we're doing this retroactively. Why is it being recommended that we do it retroactively as opposed to doing it as of today moving forward? Just if you can cure, I know you're not an attorney, but you have rationale for why we're approaching it that way, because I don't remember us doing many things on that basis.
Right. So there were concerns about water quality, and so it felt that it was a prudent decision to move forward with that service now being provided by the town. So that way that water is sourced from the town and instead of those wells that were nearby the Lear Corporation.
Okay. And quick follow-up, and I know the water quality was a big problem. It looks like I assume it was going to cost more money to address the water quality issue than to provide the connection and send it over to Fuquay to take care of it. Is that correct?
Yeah, this was the more cost-effective approach. When you look at the filtration that was already in place, the maintenance tied to that, and then the potential for the need for additional filtration to address iron and manganese, this solution is the most cost-effective.
And this was a pretty small system, as I recall.
Correct.
Okay. All right. Well, I'll go ahead and move approval. I mean, we just don't do too many things retroactively. I guess, in the future, I'd rather us not approach it that way unless we must.
That
Thank
is
you.
duly noted, and we will try our best.
Thank you.
Second.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. Additional questions or discussion or questions on the motion? All right, hearing none, all in favor indicate with an eye. Is there anyone opposed? That motion carries. Thank you.
Thank you
Ms.
very
Lawrence.
much.
All right, public staff, item 4.
Good morning. I'm Lindsay Darden, engineer of the Public Staff Water, Sewer, and Telephone Division. Presenting agenda item number 4, it's docket number W-218 sub 601. Aqua North Carolina filed a verified petition to amend its tariff for the purpose of passing along to its sewer customers in the Hawthorne at the Green Apartments, Woodland Farm, and Beaver Farm subdivision an increase in the cost of purchasing bulk sewer service from Carolina Water Service. The public staff recommends that the proposed order be issued approving the recommended tariff revision.
Move approval of staff recommendation.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. Are there questions or discussion on the motion? All right, hearing none, all in favor indicate with an eye. Is there anyone opposed? All right, that motion carries. Thank you, Ms. Darden. Public staff, item 5.
I was going to present agenda items number 5 and 6 together.
Okay.
Items 5 and 6 are filed by Aqua North Carolina and docket numbers W-218 subs 541 and 555. They're notifications of intention to begin water or sewer utility service in area contiguous to a present service area and for approval of rates. The public staff recommends that the commission issue the proposed orders recognizing the contiguous extensions and approving rates.
Move approval of staff recommendation.
Second.
All right, it's been moved and seconded that the items be approved as recommended by the public staff. Ms. Darden, before I call for the vote, which I will do in one second, will you let me know what rates are going to be offered to the customers acquired here?
They're the uniform rates.
Okay. All right, any questions or discussion on the motion? All right, all in favor indicate with an eye.
Aye.
Is there anyone opposed? All right, that motion carries. Thank you, Ms. Darden. All right, public staff, item 7.
Good morning. My name is Joanna Garcia Morin of the Public Staff Water, Sewer, and Telephone Division. Communication item 7 presents interconnection agreement filed for commission approval by Brightspeed of Central North Carolina LLC, Brightspeed of Eastern North Carolina LLC, and Brightspeed of North Carolina LLC. The public staff has reviewed the filing and recommends that an order be issued approving the interconnection agreement effective on the date it was filed.
You want to ask the question?
No, I'll ask.
Move approval of staff recommendation.
Second.
All right, it's been moved and seconded that the item be approved as recommended by the public staff. Questions or discussion on the motion? All right, hearing none, all in favor indicate with an eye. Is there anyone opposed? All right, that motion carries.
Thank you.
All right, Ms. Garcia Morin, are we correct that this is your first time presenting an item at staff conference?
First time, yes.
Well, welcome and good job, and look forward to seeing more of you.
Thank you.
All right. All right, we've got the supplemental item. We'll refer to it as public staff item 8.
Good morning. Again, I'm Evan Lawrence, an engineer with the Public Staff's Energy Division. The supplemental item, electric item 8, I believe it was referred to, consists of a motion to amend and reissue a CPCN and request for a limited waiver of parts of Commission Rule R863. The public staff has included a proposed order in its submission, which includes a detailed procedural history. In short, Allender Holloman Solar was issued an amended CPCN for an 80 megawatt facility on June 20th, 2018. However, the facility has been operating outside the bounds of the CPCN, operating at 99.9 megawatts since June of 2020. In the course of performing due diligence for a pending sale of the facility, the applicant discovered its mistake and that it failed to notify the commission of the change in capacity pursuant to Commission Rule R864 D3. Prior to commencing operations at the higher capacity, the applicant did receive approval from PJM through its interconnection study process to operate at 100 megawatts. In its application and through discovery, the public staff believes it has received enough information that it typically has through the traditional EMP application process are alleviated. The public staff believes that the failure to comply with the applicable requirements may be excused in this specific instance, and notes that the applicant is now on notice of its requirements to notify the commission of any further changes to the facility under Commission Rule R863. The public staff recommends that the commission issue the CPCN the public staff recommends that the CPCN in docket number SP 5259 sub 0 be canceled, that the request for waiver of the several requirements under Commission Rule R863 be granted, and in docket number EMP 120 sub 0, the commission issue the requested CPCN subject to the conditions in the proposed order.
I move that this agenda item be taken upstairs to executive conference.
All right. Before I call for a vote on that motion, I have several questions for the applicant. Anyone on behalf of the applicant? All right, Mr. Drews.
David Drews appearing for the applicant.
All right, Mr. Drews, what can you tell us about the lapse of time here between, why did the applicant fail to notify the commission of this change in the operational characteristics such that it was no longer qualified to operate as a QF?
So I reviewed the docket this morning. They got the CPCN in 2015. They did some amendments in 2018. Then in 2019, they planned to change the inverter capacity to allow for 99.9 megawatts AC instead of what they had been approved for in the CPCN of 80 megawatts. This emergent plant, the docket filings all over that period of time were signed off by a project manager with the applicant who is no longer employed there for, I'm sure, unrelated reasons. But because of that, I don't really have any history as to the reason why they didn't apply for the inverter upgrade, other than it was obviously an oversight. They've got FERC approval for the sale transfer that they're seeking right now. They had PJM sign off and they got their interconnection agreement when they did the inverter change to increase the AC capacity. And I think they thought that was all they had to do. And so they really missed the ball on this additional compliance requirement with North Carolina.
All right, thank you, Mr. Drews. Is the transaction that you've referred to and that Mr. Lawrence referred to, is that transaction still pending?
It is, and in fact, getting the CPCN from this commission that's been applied for today is the one and only thing that needs to be done before closing.
Does the transaction involve the sale of any assets other than this particular solar facility that we're discussing this morning?
Not that I know of.
Okay.
And I have not looked at the actual agreement for the transfer.
Okay. Does the applicant or an affiliate of the applicant own any additional facilities in North Carolina that sell into PJM?
I'd have to get back to you on that. They are a very large solar developer, so it would not surprise me if they did.
Okay, and you might anticipate my next question, which is, have there been changes at any of the other facilities of this same nature that would result in facilities no longer being qualified as QFs and needing additional regulatory approval from this commission?
Right, and I'll have to ask them to
Okay.
review that and provide that information.
Okay, Mr. Lawrence, questions for you and the public staff. You indicated that you all, the public staff, had reviewed this application, this request. You had done some due diligence or discovery with the applicant as to concerns that the public staff typically has with respect to EMPs. And obviously, my assumption is your concerns were satisfied as you all are recommending approval of this applicant's request. But help me understand what are the nature of those concerns?
The biggest of those concerns is the cost impact to North Carolina ratepayers, and this facility, through previous EMP applications, we've seen affected system costs in Dominion's territory. The facility owner picks up the rest of the costs, they pay for it, so it's not as much of a concern. In this case, there were no affected system costs included in what they were studied. It was really after this facility was studied, we started seeing more of those costs through other EMP applications, and so there was no cost impact there. They received their appropriate. They did their appropriate studies with PJM to make sure that it was safe to interconnect or to operate at 100 megawatts. One of the things they appear to have completed the necessary approvals except for this CPCN. So we realize we're not happy with that oversight by any means, but we realize through the course of the application, we very likely would have filed requesting that this application be approved at the time as an EMP as well. So we believe that there was really no harm to any other group here.
Okay. Thank you, Mr. Lawrence. When you say you're not happy, the public staff is not happy with the oversight, you mean the oversight on the part of the applicant to fail to file a request for permission with this commission?
That is correct.
Okay. You've indicated that the applicant worked with PJM and Mr. Drews did the same thing to study the output at 100 megawatts or 99.9 megawatts, whatever it is. You also, Mr. Lawrence, mentioned affected systems. Did DEP study the system at 99 versus 80?
I do not know for sure. Reading the PJM interconnection reports that were provided, it does not appear that this would have been studied. I don't know that they, through the PJM process, that they would have been notified. I also don't know that they wouldn't.
Okay, so here's my question. This is sort of the nature, the reason for my question. And I recognize that your answer is you don't know whether this change from 80 to 99 would have triggered an affected system study for DEP or not. Do I understand your testimony correctly? Okay. Is there any operational concern for DEP when you have a facility that goes from 80 to 99? I'm not asking you to answer that question, but that is my question. So what we have before us is a facility that was studied at 80, was approved at 80. Now it's gone to 99 or 100. And we don't know whether DEP has looked at that change, approved that change, authorized that change, indicated that change doesn't have any operational impacts on its system. That is of concern to the commission. Does the public staff have concern about others of these types of facilities that are interconnecting into PJM, but locating in North Carolina and obviously affecting DEP system, doing this same thing, sort of making changes to the facility outside of the regulatory oversight of the public staff and the commission, and perhaps DEP, thereby causing problems on DEP system that then the DEP customers are going to have to deal with?
So Yes, we do have that concern. However, the way that this facility went about it, since they didn't just start operating at 100 megawatts, they went through the proper interconnection study, then that this really had no bearing on whether Duke would have been notified or not. They would have been, because that interconnection procedure was completed appropriately, Duke would have been notified the same as if they would have came in for the CPCN.
Okay, that's helpful. So that's helpful information. So what I'm hearing you say is the applicant worked with PJM to study the increase. And were there an operational concern for DEP, PJM would have notified DEP?
That's correct.
Okay, thank you. That's helpful. And I assume that would be the case in any instance where a solar facility or a generating facility, let me be clear, is interconnected with PJM and works with PJM to modify its system, then PJM would be responsible for notifying any affected systems?
That's correct.
Okay.
As long as they work with PJM, then that process,
Okay.
that part of the process would be
Okay.
completed appropriately.
All right. Mr. Josie, I see you standing up.
Robert Josie with the Legal Division of the Public Staff. I was just here to answer that question if Mr. Lawrence did sufficiently do so, but he did.
Okay. Okay. Good job, Mr. Lawrence. One more question. Mr. Lawrence, I'll ask you, Mr. Josie, you can chime in if necessary, but do you and your colleagues, Mr. Lawrence, have concern about this sort of in general, that facilities could modify outside of the oversight or sort of without the knowledge of you all in this body, the commission, and cause impacts to the system? And if the answer is yes, then do you all have, does our current regulatory paradigm require sufficient sort of notification obligation on the part of the generator?
Yes, we do have that concern, and there are a few ways we do look at facilities to check this. And through the fuel case, there are or the annual fuel riders for each of the three utilities. They have, for Duke Energy, Carolinas in Progress, not Dominion on this part, they do have their QF cost recovery in there as well. We will sample facilities to look at their payments and the energy and match that up. So, but that, there are a lot of facilities, we can't audit all of them. If there are some that are operating outside the bounds, then we haven't seen them yet. And so I don't know if I can fully answer that question, because as far as I'm aware, this is the first case we've seen this. So I don't know that other people or other facilities are or are not operating outside of that. So I don't know if this is a case of everyone's doing a good job or we haven't seen it. So.
Okay.
Yeah, I would just add that while we are concerned if this is happening outside the bounds of regulatory oversight, there is a rule in place for this particular situation. And if you follow those rules, or if the facility follows those rules, then we shouldn't have an issue and we should be notified of this and the commission should be notified of it. We would like to hope that we would catch this more often if it were happening, because we are more in tune with the PJM study, interconnection study reports than we were at, the time that this facility was studied. So it's possible that we would be more likely to catch it now or in the future. But again, had the applicant notified the commission pursuant to the rules, pursuant to the certificate and the commission order, we wouldn't be in this situation.
Okay. All right. Thank you, Mr. Josie. Let's see if there are any additional questions for, go ahead, Commissioner Kimbright.
This is to Mr. Drews. To follow up on Chair Mitchell's question, would you confirm with the solar developer that for any of their facilities, merchant facilities in North Carolina, which they have changed the equipment or upgraded the equipment or switched out the inverters, that this situation has not occurred for any of the other facilities? In other words, affirmatively tell us that this situation is not occurring for any of the other facilities.
Yes, I will. And I made a note on that already. If the commission wants, we can file a letter in this docket to that effect.
Yeah, please do.
I will just add, there was one question earlier about whether or not this facility's owner was, and the applicant had other facilities in North Carolina. It is Sun Energy One is the ultimate developer and owner of this facility at this current time, and they do own several facilities in eastern North Carolina.
And I believe a list of those facilities was in the EMP application as well. That is part of that,
Okay.
that process.
All right. Thank you, Mr. Lawrence. All right. If there are no additional questions, we've got, just as a reminder, we've got a motion that's been seconded to take this item upstairs. All in favor indicate with an eye. Aye. Is there anyone opposed? All right, that motion carries. Thank you all very much. All right, commission has before us our minutes from the November 27th staff conference for approval. I'll take a motion, please.
Will be the-
All right, all in favor indicate with an eye. Is there anyone opposed? All right, those minutes are approved. Any additional business for the commission this morning before we adjourn? All right, seeing nothing, we will be adjourned. Thank you very much, everybody. Let's go off the record.